All right, we're now broadcasting worldwide over the YouTube platform. I'll throw this switch. And we are now on the record. I'm calling case number 23-000930NO, styled ELITHA, last name SUMMERVILLE, as guardian of a person whom we'll identify as VS, because that is an adult person who is a ward because she's under a guardianship of her mother. The defendants in this action are St. Mary Mercy Livonia Hospital and Trinity Health Michigan. In the order in which your client's name appears in the caption, I'll take appearance of counsel for the record, please.
Attorney Gasper, on behalf of plaintiff.
Good afternoon, Your Honor. Enrico Tutoroli appearing on behalf of the defendants.
All right. This matter was set for 1:30. I spent first things first, 3 attorneys met, talked a bit privately outside the court's purview. The 2 individuals just placed their appearance on the record, and also for plaintiff, Mr. Jonathan Marco. I then brought folks in. Mr. Marco had another commitment. The good news is, because of your long-winded judge, it's as if he never left. We've engaged in discussions about the status of this case, what's coming down the pike. The court will be issuing a new order, quite similar to the order issued December 15, 2023. The order will provide for a June 3, 2024 witness list filing and service deadline. Again, include addresses, telephone numbers, and for experts, the field of expertise. The current efforts at discovery will continue. Discovery will be completed on or before October 25th, 2024. That being a month to the day, even though November has, because November doesn't have 30 days. And the mediation with Mr. Robert Riley will commence at 1 p.m. on November 25th, 2024. Likely it will be in person, but again, I leave that to the lawyers to address. One of the other issues that bears discussion is the fact that this case will be at that point approaching 2 years. It is necessary to get cases from start to finish that are civil actions completed within the 2nd year anniversary of the filing date. This action was filed on January 23rd, 2023. We'll be discussing a trial date, likely in January of 2025, which is going to be pretty close to the facilitation. And if Mr. Riley is unable to mediate this case to full settlement, he then will act as case evaluator and issue a number that could be accepted or rejected, probably on a much shortened time frame, probably 2 weeks instead of the 28 days regularly allowed. After much discussion, it seems clear that we're going to go in an odd order, but so be it. We're going to start with one of the 2 objections. The court conducted a hearing way back on, bear with me, I have to look at the top of my cheat sheet, April 22nd, 2024. Some orders were submitted and have been entered. We had a number of matters up that day. According to my notes from that day, there were 11 separate documents filed that were in the nature of motions. In the ruling, 2 orders drew objections. The first of the 2, here we go. One we're calling the QPO, that is the Qualified Protective Order. I'll hear argument on that objection. The other objection, or proposed order that drew an objection, we're going to call the Deposition Order, or DEP Order, either or. We're going to hold off on that. Counsel have agreed to submit by email to my judicial attorney a transcript of the deposition of the person we'll be referring to on the record as the male patient, and I will review that. It'll be submitted in camera. It is to be kept out of the public parlance and view. And it's believed that that transcript, in addition to additional briefing regarding how depositions should be conducted in this case, will allow me to properly address the subject of motion practice back on April 22nd. So we'll start with the QPO. We'll skip the DEP order for today, schedule it for a future hearing date. Then we'll move on to plaintiff's motion for security for costs, filed April 9, 2024. And the grand finale will be defendant's motion for leave to file a late notice of non-party fault pursuant to Michigan Court Rule 2.112, subpart K3. That motion was filed April 11th, 2024. And as I understand it, for plaintiff, Mr. Marco will argue that motion. Have I provided a full summary of what we've discussed on the record so far with the dates and deadlines and the fact that Mr. Riley will be acting as mediator, and if he can't get the case settled, he'll be acting as case evaluator with case evaluation sanctions in play pursuant to the former version of Michigan Court Rule 2.403. Can you give me a yes to that very long question first, Mr. Tusharoni?
Yes, Ron.
Can you also give me a yes to that question, Mr. Stare?
Yes, Judge.
Excellent.
One thing, real quick, I'm sorry to interrupt. I understand the court's ordering a case evaluation ruling, but we do not consent to a case evaluation award. We're not willingly agreeing to it. I just want to make that clear.
Well, just so we're clear, I believe that was handled by a prior order of the court entered December 15th of 2023. So whatever that order provides shall be continued. Mr. Hodgman, my judicial attorney, pointed out that the problem with that order is the judge allowed all those deadlines to pass. So the terms of that order will control. But I also reminded everyone that Michigan Court Rule 2.405 regarding offers of judgment, that can be used by the parties because the provision that offer of judgment sanctions were unavailable if there was a unanimous case evaluation. That provision has been eliminated. But with all that said, we should get going. First up is the objection to the QPO. Because there was no competing order presented, I would propose, Mr. Starry, it would be easiest for me, which is why I'm making this request, if you could present the original order using share screen and then show me the changes you want to make to it as you argue. Maybe this is obvious to everyone, but I'm a visual person. And so while I can understand the arguments made, sometimes when we throw an order up and highlight the information that needs to be redacted or asserted, that can speak volumes. So are you comfortable proceeding in that fashion?
Judge, yeah, for what it's worth, though, my motion did take a screenshot of their proposed order, so it's already embedded in my motion. And I can
No, I'm expecting you to take that document and put it on the screen. That's what I'm asking.
Okay, let's see if I can do that. All right, I am pulling it up now, Judge. You see it?
Yes, but do zoom in. Again, there you go. Click a couple more.
Oh, Mark, yep.
There you go. All right. And then scroll down to that portion.
May I proceed?
Yes.
Okay, so a few things that plaintiff is objecting to, Judge. First is in paragraph 2 of their protective order, specifically the wording here that I'm highlighting. Excuse me, right here. Without having to provide notice to plaintiff's counsel, our understanding is that's not what this court ordered, is that these secret ex parte meetings that defendants want to have with plaintiffs treating providers still requires reasonable notice to plaintiff's counsel. So that's our first objection there, Judge, again, specifically embedded towards the end of paragraph 2.
You're talking about the penultimate sentence in paragraph number 2 of the proposed order, and you propose to strike the lines or the words without having to provide notice to plaintiff's counsel before. You agree?
We could say
no, that's
all the way to the same if we're going to completely strike it out.
Okay, so strike from the comma after capital C counsel, which is in the 6th line. So there would be a period after capital C counsel, and we would strike comma, and for those covered entities who have been disclosed. No, that's not true.
It would be just here, Judge, I'm highlighting.
Just the comma after litigation. So it'd be comma without having to provide notice to plaintiff's counsel before engaging in same. That's the proposed first strikeout. Yes?
Correct, Judge.
All right. And then next?
Yeah, next is, it's a little more tricky to explain, so I'll just try to jump right in and articulate. The entirety of paragraph 3 in defendant's proposed order, Judge, if you recall, Your Honor, you required that notice be given directly to the treating providers, exactly as it sort of outlines here, that they have an opportunity to have an attorney with them, they have an opportunity to even reject a meeting with them, et cetera, et cetera. The problem is the way that they word paragraph 3, Judge, is they are putting the notice within the order itself. They're saying the covered entities who render treatment to VS are put on notice. Well, that's not what the notice was. The notice isn't supposed to be embedded in the order, Judge. The notice has to be specifically and directly provided from the defense to the treating provider with whom they wish to meet with. So that's my concern, is they're trying to essentially say that they're fulfilling the notice requirement by embedding it in the order without actually giving direct notice to the medical providers themselves. And so we're saying those are two different things. Of course, they have to provide a copy of this judge's order, absolutely, but the notice provision itself, as Your Honor ordered, that's a separate document that has to be given directly to medical providers. So we're essentially saying that they should not be able to double dip, so to speak, and that the notice has to be distinctly separate from the order itself.
Well, no, what you're saying is,
Steve,
that you want it to be stated twice, once in the order and once in the correspondence. Could somebody mute whomever else is talking?
Hey, John.
I wasn't talking. I was on mute.
That leaves only 2 suspects. So
I'm in a basement, Judge, with no sound whatsoever.
it leaves 1 suspect. But let's do this.
Yep.
Your request is that the language be put in. I mean, it should state that in the order.
I mean, it should say that the order should definitely confirm that notice is required, that the defendants are required to provide notice to the treating providers, but that notice itself is distinctly outside and separate from the order. So yes, I agree, notice is required. We're seemingly all agreeable on that fact, but that notice itself should not be embedded in the order.
Okay. All right. So again, part of the reason to provide a competing order. So what you're saying is 3 can stay in, and you want 3 expanded to say, and, comma, moreover, counsel for defendants shall communicate this information to each covered entity each time defense counsel communicates with the covered entity, or words to that effect. Yes?
I would word it differently, Judge.
Well, regardless, what I'm saying is this stays in, and moreover, with each written and verbal communication with medical personnel, that this information has to be provided, right?
Correct, with advance notice to us as plaintiff's counsel as well.
We're going 1 objection at a time. You've already covered paragraph 2. This is paragraph 3.
I'm hearing what's up.
Again, there's background noise.
Okay.
Okay.
Citation is completed.
So I don't know that the objection regarding the word guardian really needs a ruling, or maybe it does. Address that point next.
Yeah, yes, Judge. Yes, that separate point that'd be in paragraph 4. I mean, we already addressed this off the record, Judge. You indicated and advised and instructed defense counsel to ensure that their whatever system going on typos doesn't continue to happen. We established that Letha Somerville is the guardian, and so again, that wording is improper. And I would also just strike out for the purpose of information is to assist the defense party in defense of a lawsuit. I mean, that's essentially irrelevant, and it's not what Your Honor ordered, but I won't. We can leave that in there as long as we clearly identify guardian.
If I may, so the only change to paragraph 4 would be to change as next friend of VS to as guardian of VS. Agreed?
Correct.
Okay. And then the balance of this seems to relate to the 3 points made. So briefly, Mr. Tusharoni, I assume you agree to the third of the 3 items raised today as it relates to paragraph 4. And
We will change the guardian.
I'm going to ask a question, though, and change as next friend of VS to as guardian of VS. Yes?
Yes, Your Honor.
Perfect. As it relates to the second point, and you can end the screen share. As to the second point, I appreciate the concern. I'm a fan of the belts, the suspenders, and the duct tape when the situation requires it. Do you have any objection adding to paragraph 3 words to the effect of and with each communication, comma, whether in writing or orally, comma, this information would be repeated or stated to each covered entity? I assume you can agree to that, Mr. Tusharoni?
Well, Judge, I fear that's going to have a chilling effect. That's a condition that the SPAC case that was originally cited in our original brief for this motion said that there has to be good cause for any conditions. Otherwise, there should be no conditions. Essentially, by asking me to put in letters.
No, let's pause. You're telling me why. I just want a yes or a no. Your position is this is sufficient.
Yes, because if you also look at paragraph 10 of the order, it again says we're allowed to request. The doctor's not allowed. It's not required to comply. Essentially, they're asking for a redundancy.
All right. So.
Oh, and it says that they can take the advice of an attorney.
Let's pause.
On paragraph 10.
Show me where, read the provision or screen share, if you would, Mr. Tusharoni, the provision that requires a copy of this order be provided to medical personnel. Paragraph 10.
Paragraph 10. Do you see that, Judge?
I'm looking right at it.
Okay, I just want to make sure I have the right order up.
All right. And then let's go.
then-
So I feel I've got enough information on the second and third points. And now let's go back to the first point. Give me your argument, Mr. Tusharoni, as it relates to whether or not advance notice needs to be given by defense counsel to plaintiff's counsel.
So, Your Honor, this was addressed at the oral argument back on the 22nd. The court, and I took meticulous notes because I know you're very particular about your orders. You specifically said that there is no notice requirement to opposing counsel. That's why paragraph 2 says what it does. SPAC case specifically negates notice requirements.
Spell that name.
I believe it's SPZAK. I don't have my original brief up on my computer. I can pull that if I need to give you the citation.
No, it's just, it's one of those words that doesn't roll off the tongue. Although it's by Irish heritage, maybe my lack of Polish heritage or Serbo-Croatian. All right.
Judge, those are medical malpractice cases. They're not applicable here.
Right. Any further argument on this order, Mr. Tusharoni?
Well, to address what Mr. Starry just said, the original case discussing the need and the requirements of this QPO was a products liability case against Volkswagen, I believe. But I believe, in light of the notes I took, when you were itemizing the requirements or the terms that were requested that were not to be put in the QPO, that this order that I submitted accurately reflects your ruling back on the 22nd.
All right. Thank you. Anything further, brother counsel, Mr. Starry?
Yes, Judge, an argument?
Right.
Yes. First is that to simply put it, to tie up paragraph number 3, Judge, we can put via this qualified protective order and authorization, the covered entities who render treatment to VS are required to be put or given advance notice. That's all I'm trying to argue here. Just give advance notice. Don't use the order itself. I understand paragraph 10 requires that the order be given to them, but that's not notice in and of itself. That should be separate. And that's how I understood Your Honor's ruling. Furthermore, you did require that we be given notice, reasonable notice, as plaintiff's counsel. And then ultimately, Judge, with paragraph 2, you never gave them that just complete vague discretion to determine whenever they want to do this. That was never part of your order. And my other concern is with that last paragraph that we went over, explicitly number 4, the quote phrase, the purpose of the information is to assist the defense party in defense of a lawsuit. Well, that's not the entirety of it. For all we know, they might be using this information to try to file a claim against somebody else, or there's a whole host of other motives, so to speak, that could be used behind that. So my only concern is by adding that final sentence to paragraph 4, it kind of lightens the intent of what defense counsel is trying to do. It certainly wasn't this court's order. Your Honor did not make that order that much certain.
Judge, if I may.
You may.
I am not some evil, nefarious Bond villain that Mr. Starry wants to make me out to be.
I didn't say that, Judge.
The paragraph,
We're not going to
paragraph
interrupt.
that says,
If you hear my voice, you must stop. Please don't interrupt. Brother counsel, please, Mr. Starry. Mr. Tusharoni, continue.
so that language that says the information is to assist defense party in defense of a lawsuit, that has been in my order for years and years and years. This is something that a plaintiff's attorney requested of me years ago. Essentially, and I don't know what additional notice, because essentially what happens is I find a doctor that I think we need to meet with. I send them a letter requesting the meeting and it closes this QPO. What other notice am I supposed to give other than, doctor, can we meet with you to discuss your treatment of VS? Here's the QPO signed by the judge that allows me to request this meeting. We then get to the order that says you can have an attorney You can refuse. It's a defense attorney that's asking for this to investigate a lawsuit. I don't know what nefarious things they think I'm doing other than requesting meetings with treating physicians, and I'm following the law that requires me to have a QPO in place to do that. That's what this is. The court said I don't have to give them notice because the court agreed with our argument that giving notice reveals work product, reveals thought processes. Mr. Starry and Mr. Marco have unfettered access to each and every
So let's
person that
pause.
ever treated.
Respectfully, I'm talking, so you have to stop. It feels like we're re-arguing the motion. That's not helpful. So anything else you feel the need to raise as it relates to your response to the objections to the proposed order?
No, Your Honor, I believe it accurately reflects everything you ruled on that day.
All right. Anything further, Mr. Starry?
Yes, Judge, we have a right to know. We have a right to know. We are required to give notice. You made that in your ruling. There's why is defense counsel so? I mean, they're making these accusations. I'm saying that he's being nefarious and all these things. What's the problem with giving us reasonable notice? What's the problem with that? And what's the problem with adding in his letter when he sends these letters out to providers? What's the problem with adding in? Hey, you're also on notice in addition to this hash qualified protector or this court's order. You don't have to agree to meet with us. You have a right to. What's wrong with adding that in the notes itself? And furthermore, Judge, defense counsel just stated that we have unfettered, tethered access to anyone who's ever treated Victoria Somerville. Let's be clear here. Numerous treaters of the plaintiff are defendant's hospital staff. She was admitted to their mental health unit. So that is an absolute misrepresentation to the court to say that defense counsel has no access to plaintiff's treating providers. They're right there, the defendants. Dr. Hope, Dr. Stevenson. Those are just to name a few, Judge. So that's absolutely a complete misrepresentation by opposing counsel to say that they have no access to any treating providers that have ever treated plaintiff, Judge. That's wholly inaccurate. Bottom line is we are absolutely entitled to notice, and Your Honor ruled that we are entitled to reasonable advance notice when defense counsel makes these requests. That's it.
Your Honor, I can meet with my staff without HIPAA QPO. I cannot meet with prior or subsequent treaters. That's what the purpose of this QPO is for. Plaintiffs don't need a QPO to go meet with prior or subsequent treaters of VS.
And they're not saying they do, so that's a straw man argument. Anything further, Mr. Tusharoni?
No, Your Honor, if this meets your ruling.
Anything further, Mr. Starry?
No, Judge.
All right. The good news is there's enough guidance from the Court of Appeals on how to proceed. The Court of Appeals peremptorily reversing a decision of a trial court is excellent guidance because it is something that is unusual. The case relied on by defendants is SZPAK versus INYANG 290 Mishap 711-2010. In multiple docket numbers, and here I'm looking at 310181 style DILWORTH-STRICKLIN versus St. Joseph Mercy Hospital Ann Arbor. The court ruled, the order is, I missed it, dated January 4th, 2013. The panel, Judges Hoekstra, HOEKSTRA, Markey, MARKEY, and Beckering, BECKERING, now of the federal bench. That order reads, the motions for immediate consideration are granted. The motion to stay pending, proceedings pending appeal is denied. Pursuant to MCR 7.205, subpart D2, in lieu of granting the application for appeal, the court peremptorily reverses the decision of the trial court to include in the April 2012 qualified protective order the provisions directing defendants to give plaintiffs notice of and an opportunity to attend ex parte interviews by defense counsel with the treating physicians of plaintiff, I'll skip the name, and directs that paragraph G be stricken from the order. The court abused its discretion when it imposed these conditions in the absence of identified facts specific to the case, showing that justice required the conditions. The same is true here. While I often will go back and forth trying to plumb the depths of an issue, it is clear to me that there is inadequate cause for me to insert a requirement of notice. Thus, I'm overruling the objection to that portion of the language in paragraph 2. Moreover, I believe that in light of the fact that the order will be provided to medical personnel, that there doesn't need to be a recitation. The mere fact that a court order is being provided and that Mr. Tusharoni or somebody from his law firm are directing people to review the court order, I believe it's sufficient. I, in fact, would prefer somebody to look at my order instead of a lawyer's paraphrasing of the same. I am requiring that the word guardian be used in the order and in the caption. I know mistakes happen. And so if there is a mistake, my expectation is counsel will address it between themselves and figure it out. I understand Mr. Starry's concern that an order being received by medical personnel that is inaccurate, indicating a next friend relationship instead of a guardianship, how that could be confusing and misleading. So that is the only change I'm making. The order shall be exactly as drafted, except capital G guardian will be set in place instead of next friend. Have I ruled on all aspects concerning your client's objection to this order, Mr. Starry?
I didn't hear anything for 3. Did I miss that?
You're confusing me. 3 was where you wanted additional language to state that what is stated has to be repeated. Am I mistaken in that regard?
Yeah, so essentially you're overruling our objection to 2 and 3, but you're sustaining the objection to 4, is my understanding.
The way I'm ruling is the order will be exactly as drafted, except the words next friend will be replaced by capital G guardian. The,
I'll make sure the caption itself is fixed as well.
right. And again, I'm not going to hopefully spend any time policing the caption, at least as it relates to this order. It better be clear that the role of Aletha Somerville is as guardian, because that is a role of significance that even medical personnel and whatever lawyers work with them cannot misunderstand. So that's the first ruling. Next up is the motion regarding the request for security for costs. Do you have anything you want to add to the papers as drafted, Mr. Stare?
Add to that, no, Judge.
All right. Can you rest on your papers as well, Mr. Tusharoni?
Pretty much, Judge, but the deposition of the male patient on April 30th does now play a role in that motion.
All right. What would you wish to add?
So the male patient testified that he revoked his HIPAA authorization. And we don't have the exhibit yet from Mr. Stare, who has it in his file, but exhibit 1, or was it 2 to that deposition, is the 2-page St. Mary's authorization with the male patient's original signature, both on the authorization and on the revocation. We have the transcript. We don't have the exhibits. Those are entirely in Mr. Stare's possession. We did not have access to a copier or cameras because we were in the jail taking this deposition. So I don't have those exhibits yet. Those were supposed to be provided to the court reporter. But regardless, the deposition testimony was that the male patient revoked his HIPAA authorization, did not want us to discuss his medical care at St. Mary's, did not want his physicians discussing his medical care.
Pause. It feels like there's a gap here. We're talking about plaintiff's motion for security for costs.
So the reason I'm bringing that up, Judge, is because when you look at their motion, it's based primarily on the medical records of the male patient, who has now revoked his authorization to have us discuss those or use those in this case. They want this court to make a finding of fact of a sexual assault.
Judge,
They are claiming that please don't interrupt me. They are claiming that my defenses are frivolous and inconsistent, even though the court rules allow me to plead inconsistent theories and defenses. This is this motion is a slippery slope. Anytime a defendant and plaintiff disagree on the validity of a case, of the claims, or the validity of the defenses, we're going to start imposing $2 million bonds by asking the court to make a finding of fact, by asking the court to declare defenses frivolous before 75% of the depositions are done in the case. This is unusual motion. Nothing I've ever had to see or defend before. It's just, there's no basis for it. It's essentially a harassing motion based upon medical records that we are no longer not allowed to use in this case, based upon the fact that they don't like my defenses. There's just no grounds for it. There's no rational basis to impose a $2 million bond for me to continue to defend this case. It's absolutely unfair. That's really all I have, Judge.
All right. You may now unmute Mr. Stare. Please, I don't want either of counsel to interrupt each other. You may proceed.
Thank you, Judge. I'm really concerned that opposing counsel here is trying to, or intentionally trying to confuse Your Honor. If you recall, defense counsel began his argument in response to plaintiff's motion for security bond costs, which is specifically pursuant to MCR 2.109, stating that, oh, well, we took the deposition of the male patient, and based on that deposition, that essentially makes our motion frivolous or otherwise moot. Let's be clear here. The male patient's deposition has absolutely nothing to do with our motion whatsoever. His testimony, that deposition, does not change our legal ground, nor does it change the court rule, specifically 2.109, regarding our motion for bonds and costs. In fact, you don't need to look any further, Judge, because defense counsel went on to argue to say, well, we can't talk about these medical records anymore, specifically pertaining to male patient's medical records, because of the male patient's deposition testimony. Well, Judge, look no further than the next motion on your docket that you're going to hear today, which is defendant's motion to file leave for late notice of non-party at fault, Judge. They knew from the very beginning, regardless of the male patient's deposition, Judge, they knew from the onset when the Livonia PD police department was called and brought to their hospital and a huge criminal investigation was conducted. They knew from the jump that this male patient was involved. And yet, with their defenses, they filed a whole slew of frivolous defenses, despite knowing this, despite having access to his medical records, Judge. These medical records, plaintiff's counsels, we obtained these medical records from 2 separate avenues. The first was via lawful subpoena to the Livonia Police Department, which defense counsel tried to argue they were never put on notice. I shared my screen with you and showed you, no, we gave you notice, we showed you that subpoena and provided a copy to you. That was the first avenue, the Livonia PD subpoena. The second avenue, which defense counsel also admitted, was through, at the time, proper and full waiver of his HIPAA rights. Defense counsel conceded that the male patient did not waive or did not revoke, his HIPAA rights until the middle of that deposition itself. Regardless, Judge, the bottom line is all of that to the side. The hospital knew from the very beginning when they themselves called the police. They called the Livonia Police Department. There was a giant criminal investigation conducted. In fact, Dr. Hillary Stevenson herself, one of the doctors on behalf of the defendants, she even testified during her deposition that she conducted her own quote unquote interview, which is essentially an investigation of what transpired between plaintiff and the male patient. And that's further corroborated by the male patient's medical records. And so, yes, MCR 2.109 does in fact entitle us to bond and costs when it appears reasonable and proper to cover an amount sufficient to cover all costs and other reasonable expenses. I mean, Judge, we know that this case is a bit complex. We do know that there's a lot of issues that Your Honor still has to resolve and that the party still needs to brief on, but the bottom line is this: liability is undeniable. Plaintiff was sexually assaulted as an admitted psychiatric patient within the lockdown unit of the defendant's mental health unit. They were fully and undeniably responsible for her supervision and care, yet despite that, she was still sexually assaulted. None of that is contested. None of that. But what they are contesting is whether or not, I mean, I can go into the Judge, they, in their own defenses, affirmative defenses they file, they say that plaintiff lacks standing to bring forth this action. Then at the same time in their affirmative defenses, Judge, and I have no problem sharing the screen with you, Judge, and showing you, they then say at the same time that plaintiff doesn't have mental capacity to bring this case before you, Your Honor. They then say that she had the mental capacity to consent to the sexual assault. I mean, they knew from the very beginning, even their affirmative defenses themselves identify the male patient. They don't use his name specifically, but they mention the male patient, yet they fail to ever notice him as a non-party fault, which is the motion that's preceding this motion, Judge. The bottom line is MCR 2.109 does entitle us to bonds and costs, specifically when we have the facts that we have here before us. They knew from the beginning, they filed frivolous defenses. the frivolous defense after frivolous defense, refusing to accept any responsibility whatsoever. But the bottom line is they knew from the very beginning, and in fact, it was them themselves that called the police because they knew what just happened was wrong. No one should ever get raped or sexually assaulted on a mental health unit in a hospital, and that's what happened. That's it, Judge. Thank you.
Your Honor, may I respond very
No, you may
quickly?
not. Respectfully, I think there's a misapprehension regarding why MCR 2.109 exists. Typically, it would be in a situation where a party takes a position that is hard to sustain, and the concern is a claim is being made that is, insert word here, frivolous is the one that most often comes to mind, and thus you have Michigan Court Rule 1.109, subpart E5, E6, E7, Michigan Court Rule 2.625. I can't recall whether it's A2 or B2. I believe it's A2. And then you have Michigan Compiled Laws 600.2591 on frivolous cases. The purpose for obtaining security for costs is to ensure that if somebody takes a precipitous position that is untenable, that they do have to put their money where their mouth is. The reason for it is so that one side does not go to trial and incur all the litigation costs on a dubious claim and have no source of recovery. And thus MCR 2.109 reads at subpart A, on motion of a party against whom a claim has been asserted in a civil action, if it appears reasonable and proper, the court may order the opposing party to file with the court clerk a bond with surety as required by the court in an amount sufficient to cover all costs and other recoverable expenses that may be awarded by the trial court, or if the claiming party appeals, by the trial and appellate courts. The court shall determine the amount in its discretion. MCR 3.604 subpart E and subpart F govern objections to the surety. Subpart B of MCR 2.109 talks about where such a request cannot be made. And that is similarly instructive. Subpart B1, the court may allow a party to proceed without furnishing security for costs if the party's pleading states a legitimate claim and the party shows by affidavit that he or she is financially unable to furnish a security bond. It's a judgment by the Michigan Supreme Court, because this is in the court rules, that we're not going to shut the door to people who are poor and have a claim that is not a slam dunk. Subpart 2, or B2 of MCR 2.109, provides that security shall not be required of the United States or an agency or instrumentality of the United States. That's B2A. B2B is the state of Michigan or a governmental unit of the state, including but not limited to a public, municipal, quasi-municipal, or a governmental corporation, unincorporated board, public body, or political subdivision. Or subpart B2C, an officer of a governmental unit or agency exempt from security who brings an action in his or her official capacity. So subpart C also provides further illustration. The court may order new or additional security at any time on just terms. 1, if the party or the surety moves out of Michigan, or 2, if the original amount of the bond proves insufficient. A person who becomes a new or additional surety is liable for all costs from the commencement of the action as if he or she had been the original surety. Looking at my particular favorite dictionary from the good people of Merriam-Webster, MERRIAM-WEBSTER, a surety is, quote, a formal engagement, such as a pledge, given for the fulfillment of an undertaking. Also guarantee. It is, in the first instance, the state of being sure, such as sure in knowledge, or better said, assurance or assured, meaning confidence in manner or behavior. The third of the definitions is one who has become legally liable for the debt, default, or failure in duty of another. The concern here is that this case would be waged by plaintiff, that a court could one day, whether it be yours truly, a successor judge, or an appellate court, there could be a determination that the one or more defenses were frivolous. The purpose for a bond is to protect somebody in such a position so that they don't have to go through all the work of litigation and be left, in the common vernacular, holding the bag. As is pointed out by plaintiff's own motion papers, paragraph 19 through 24. Starting at paragraph 19. In this case, considering the indisputable liability and frivolously evasive legal tactics employed by the defendants, it is entirely reasonable and proper to require the defendants to file a mere $2 million bond, given the unconscionable facts and circumstances of this highly litigated case. 20. The costs and expenses that plaintiff has incurred and continues to incur as a result of defendants' frivolous defense and tactics are both staggering and recoverable. Paragraph 21. Certainly a massive for-profit business such as the defendants could very easily post such a surety bond with little to no hindrance. Paragraph 22. An order to post security can also be appropriate where there is good reason to believe that a party's possession, even if it is not right for summary disposition, under MCR 2.116 is nonetheless groundless and unwarranted, citing Flanagan versus General Motors Corp. 95 Mishap 677 at 683 1980, The Northwestern citation is being omitted by yours truly. Paragraph 23, pursuant to MCR 1.109E7 and 2.625A2, so thanks for that direction, a party that pleads a frivolous defense is subject to costs provided by MCL 600.2591. Paragraph 24, MCL 600.2591 provides this court with further authority to award costs and fees when a defense is frivolous and defines the term as one where, quote, the party had, next three words emphasized, no reasonable basis to believe that the facts underlying that party's legal position were in fact true, close quote. Respectfully, I'm reminded of the Michigan Supreme Court's quote in Moll versus MOLL versus Abbott Laboratories. We shall not declare the bread stale before it is baked. That was in the situation where mothers who, while pregnant, were given DES, that is diethylstilbestrol, to help control nausea. And as a result of that drug, those pregnant with daughters were born with malformed uteruses such that either they could not carry children or doing so was impaired. There, the limitations period prescribed for such an action was extended as provided by the discovery rule. Here, you've got defendants that are a part of a major healthcare system. If in fact the amount sought by plaintiff is recovered, which is the only demand I'm aware of, was for $18 million. That amount, I believe, if all the appeals fail, then that's the amount awarded by a jury. That is the amount that will be paid by these defendants. And if a motion is made and the trial court determines the defense to be frivolous, then I have significant discretion on how to proceed in making an award on that basis. So here, I'm not going to declare bread stale before it's baked, nor will I declare a defense to be frivolous before discovery is completed, motion practice is completed, and spoiler alert, likely not until after the trial is completed. The allegations contained in Aletha Somerville's complaint on behalf of her daughter are awful. No one should go to a healthcare system and receive anything less than proper care. I just had a case where allegations were made regarding what they call birth trauma in March of 2024. And the jury did what juries do. It found facts, applied the law, and it issued a significant verdict of 9 figures. Here, much like the bread not being declared stale before it's baked, I'm not going to declare the meal rancid before it's baked. Sometimes motions like this are filed to help educate a trial court judge that there are concerns. The time to address such concerns will be once the trial is completed, not at this point. So while I appreciate the arguments made, it's my view that if ultimately I make the findings that are consistent with plaintiff's argument in this motion, then at that point, I'll be in a position to consider whether or not the defenses were frivolous, etc. And as one can see in MCL 600.2591, there are 3 paths, and they're not paths that are easily walked. So I'm denying the motion. Please submit an order that states, again, visual part, for the reasons stated on the record by the court, plaintiff's motion, which is titled plaintiff's motion for security bond and costs, which usually I would hear, or I would see as titled motion for security for costs, which was filed April 11, 2024, is denied. And now we're on to the third and final matter of the day. It is the defendant's motion seeking leave to file a late notice of non-party fault under MCR 2.112 subpart K3. It is the defendant's motion. You have the floor, Mr. Tuscheroni.
Thank you, Your Honor. I don't think there's much to add to the briefing that's already been done in this matter, but obviously, in light of what we have been arguing for months in this case about HIPAA protections of unnamed non-party patients, even I was not allowed to know the identity of the male patient. Then all of a sudden we get his medical records and HIPAA authorization from him from January, and technically that is the first time I'm permitted to know his identity, get his records or anything. So I identified him. Sure.
January of 2023 or 2024?
I'm sorry, 2024. I misspoke.
No, you didn't give a year. Keep going.
Okay. All right. So I meant this year. So now we have this authorization. We have these records. I get a bond motion. I'll identify and all based upon this waiver of HIPAA privileges and self-identification. That's the notice, and that's why the notice of non-party fault came out then, because technically, I'm not allowed to know his identification at that point in time. Then we get the plaintiff saying that there is clear liability. I have no defenses to this case. This guy raped and sexually assaulted VS, and I have a basis for a notice of non-party fault. That is why it came out at this point, as opposed to within 90 days after I filed an answer. There's absolutely no prejudice. We've done 3 or 4, maybe 5 treater depositions. There's 10, 15 plus more depositions to come, including those of treating physicians, treating nurses, mental health techs, security officers, Livonia police officers. Plaintiffs have ample time to investigate this notice of non-party fault. They have adequate time to amend their complaint to add this gentleman as a defendant, which is their right to do under the non-party fault court rules. And so there's no prejudice. They've known about him all along as well. So they can, all this argument that I've known about him because my doctors called the police back in March of 2022, those are all red herrings, Judge. Because the fact is, for purposes of litigation, for purposes of defending a hospital and healthcare system, for purposes of litigating this case, I'm not allowed to know, and nobody's really allowed to know his identity. And now he's shutting that door. And I know the court's going to review his transcript to make a ruling, and we're going to brief on that. But the fact is, yeah, it's not within the 90 days, but it's certainly early enough in this litigation. The plaintiffs are not prejudiced. They've known about him. They've alleged sexual assault since day one in this, since we got notice of intent in this case. They're not prejudiced. I think that it's proper. They have notice. They have plenty of time to investigate and address the notice of non-party fault as we go through for the next, through almost 9 months. If we're looking at a January trial date, they have plenty of time to investigate this. So there's no prejudice. I think it's proper, and we're requesting that you allow us leave to file this notice. Thank you, Judge.
Thank you. Mr. Marco.
You're muted, John.
Yes, Judge, thank you. Mr. Tuccioni's problem is that he's known about the identity, the defendants have known about the identity of the male patient, including his name, for quite some time, way outside the 91-day window that the court rule allows. And the court rule, Snyder versus Advantage Health Physicians, I know you will strictly apply Court of Appeals and appellate decisions as well as strictly apply court rules. The case law is clear, Your Honor, under Snyder, which is a 2008 opinion, that it is reversible error for the trial court to not strictly apply MCR 2.112K3, which is the notice of non-party at fault rule. The rule is very clear, and it doesn't matter. Prejudice is not relevant for the purposes of today's analysis. So he can say that till he's blue in the face, because under the court rule, the notice must be filed within 91 days after the first responsive pleading. The only exception to that filing window, this is applied like NOIs are applied. Because Mr. Tuccioni, I'm sure, filed a lot of motions to dismiss where there's a defect in the NOI. The courts have to strictly apply it. Snyder says the same thing goes for this rule. The only exception is if the facts on which the notice are based were not and could not, with reasonable diligence, been known to the defendant. It's not Mr. Tuccioni, it's the defendant, by the way. And two, the late filing will not prejudice the plaintiff. Those two things have to be met. They can't file this, Judge, because they blew the 91-day window and it's undisputed. This case was filed in March of 2022. The complaint clearly alleged that the plaintiff was raped by a patient at the defendant's facility. Mr. Tuccioni filed a motion to dismiss. We argued that motion, you denied it. Then the following pieces of evidence were available and in Mr. Tuccioni's possession, or they could have reasonably been known to Mr. Tuccioni from the time the complaint was filed, which was January 23rd of 2023. Number one, the hospital's security investigated the incident and took statements. They identified the patient. That is not HIPAA protected. That is under the law enforcement exception to HIPAA. Number two, the Livonia police investigated the incident, and they're not subject to HIPAA either. And that's how we got the information, because the Livonia police had to provide that information pursuant to a duly authorized subpoena that Mr. Tuccioni knew darn well about and had access to, just like we had. And so his name was identified there. Number three, and this is the most compelling because he has no way to get around this. On October 10th of 2023, there was a deposition of Hillary Stevenson, Your Honor, who was an employee of the defendant. I've cited this for you on page 8 of my brief, where at the time of her deposition, the attorney, Mr. Starre, specifically identified the male patient by name, at which point Mr. Tuccioni didn't say, who is that or anything like that. Mr. Tuccioni knew exactly who this was this entire time. And he instructed, because he had access to the same materials we had and more, and he instructed the witness not to answer and said, don't answer any questions about this male patient. That's on page 57 through 59 of the doctor's deposition. He chose not to file a notice of non-party at fault. The defendants chose not to file a notice of non-party at fault. It is way too late now. We are undisputably beyond the 91 days, even if you took the most lenient approach in view of what reasonable diligence would have been for the defendants in this case. And you have to strictly apply this. It's not optional. There's no in the interest of justice requirements. There's no weighing of prejudice or anything like that. It's game over, according to Snyder and the court rule. That's number one. Number two, it would be futile, Judge. As I cited you, the Michigan Supreme Court of Hickey versus Zelzuka, which is 439 Mich 408, 1992. That was a jail suicide case, which is analogous, although not exactly identical here. But in the Zelzuka case, the Michigan Supreme Court said that there can be no comparative fault when you have someone who suffers an injury like this inside of a custodial environment. In that case, it was a police station, which is very similar. It was a jail, very similar to a lockdown psychiatric facility. This is a lockdown facility. They have security. People are not free to leave, and they're entirely reliant upon the defendants for their needs. So it would be entirely futile, because in that case, they said there is no comparative fault. And in this case, you have another patient who is mentally incapacitated and a judge to be unable to care for himself at the time of the incident, who's placed under the care and control of the defendant. They can't then go to trial and try to apportion fault to their own patient who they had a responsibility to control and supervise. I've cited you 2 other cases that apply this principle from our Supreme Court, Johnson versus Williams, which was an opinion out of the Eastern District of Michigan by the late Arthur Tarnow. And I've also cited you cases from other jurisdictions addressing this, including the same situation that we have here, that say it wouldn't make any sense. That's the second reason. If you, for some reason, don't strictly apply the statute, the court rule, then it's a futile amendment and it's improper. Finally, I've cited to you the Bottigia case, which is Exhibit 9, Your Honor, where it deals with, quote, a person whose liability is imputed based on the tortious acts of another is liable for the entire share of comparative responsibility assigned to the other. That's Bologna versus Pavernak. It's an unpublished opinion, Your Honor, but it is instructive and persuasive. And that is 2007 Mishap, Lexus 2689. And that relied on the third restatement of tort, apportionment of liability, page 113. And so this is a fool's errand for them filing this motion, and it comes too late, Judge. There is no excuse. Even if you believe defense counsel that he did not know, that does not excuse the failure to file a notice of non-party at fault. The defendants knew, and when he found out, it was beyond the 91-day window for him to file this. I'm happy to answer any questions that you may have, Judge, but I'd ask that you strictly apply Snyder as we're required to do.
Thank you. Response.
Thank you, Your Honor. the court rule specifically talks about prejudice in it. So I am properly discussing the fact the plaintiff is not going to be unduly prejudiced by allowing this notice to be filed. When we took Hillary Stevens' deposition back in October of 2023, and Mr. Stare raised that name, I'm still under obligations to protect his HIPAA privacy. As representative of the healthcare entity that treated him, I had no waiver. I'm not allowed to use his information. And we cited to the court many cases over the course of this case about not being able to use non-party, names or identify non-party patients, including somebody alleged to have committed a sexual assault. Once he signs that HIPAA waiver, once we got all this information, the plaintiff is now saying we have admitted liability because we have his medical records, that's when the notice of non-party fault became effective. And again, that's why it was filed at that point in time. It's filed because there's, plaintiffs are going to be prejudiced. And when you look at the court rule itself, it talks about the court may permit a later amendment. Let me see, I'm sorry. The defendant could not, with reasonable diligence, have known to the moving party earlier, that would be the identification of the male patient, provided that the late filing of the notice does not result in unfair prejudice to the opposing party. And that's why I'm arguing that there's no prejudice to my opposing party, because there isn't any. We've known his identity. I'm not allowed to use it because of HIPAA protections. That's why we're filing this at this point in time. When I'm looking at plaintiff's response in the one case about allocations of fault, and that would be the Hickey versus Zazuka case, that was an allocation of fault against the person who actually committed suicide, not against a third-party perpetrator, as in this case. So that case is factually distinguishable from this. There is good cause, there's good reason to allow this notice of non-party fault to go through. I cannot use patient identifying information until that patient waives their HIPAA privilege, which he did, and they're extensively relying on, since January of 2024. So that's the purpose of filing it at this point. That's why it's there, and they're not prejudiced. They can fully investigate this. The law allows us to allege comparative fault. Comparative fault of VS, comparative fault of the male patient, is included in our affirmative defenses to plaintiff's First Amendment complaint. So they are on notice that we are going to allege comparative fault against VS, against the male patient. They've been on notice since we filed our response to pleadings. This is just a formality that memorializes what's included in the affirmative defenses. Thank you, Judge.
Judge, may I respond?
Well, I have questions for you. First, what the heck? I'll let you go first, Mr. Marco.
Just real briefly, the prejudice analysis does not come into play unless you find that they have a reasonable excuse that they could not have known the identity of the non-party at fault. And when I say they, it's the defendant. And so they could have identified it as the male patient. They could have filed a non-party identifying a male patient, or a more generic term. Secondly, when we talk about prejudice, if you grant this motion, I want you to think about how this is really going to play out. We have this male patient who Mr. Tucciarone has taken and is going to continue to take the position that I am unable to depose him on anything that occurred during the time that he was present at the hospital, because it's protected medical information. So they're going to get to go before the jury in a trial and try to apportion fault to a person that they're taking the position we are completely handcuffed and prevented from deposing or attacking or getting information related to his actions or inactions within the hospital setting. And then turn around when it's time to fill out the verdict form and say, give 100% at fault to our patient at the hospital, even though they are not allowed to do discovery or tell you anything about him and what he did or didn't do. Talk about prejudice. How can I litigate this case like that? And that's why the appellate courts strictly apply this. And that's why the appellate courts say there's no comparative fault in this type of situation. It would be crazy. We couldn't have a case if there was comparative fault in a situation like this. So we don't need to get to prejudice. You don't need to. You have to apply it. But if you do, there's a lot of prejudice to go around. I'm happy to answer your questions, Judge.
The assault, according to the First Amendment complaint, the assault occurred on the evening of March 2nd, 2022. You agree with me that that's well within the 3-year limitations period for a claim sounding in tort. Mr. Marco, yes?
Is March of 22 within a 3-year tort statute of limitations? Of course, Your Honor.
Right, that's simple math. That one is the easy one. The more challenging one is in the context of an unknown driver who causes injury, flees the scene, isn't identified. You have various statutes for typically uninsured motorist coverage that require contact, physical contact between the phantom vehicle and the vehicle covered by the uninsured motorist policy. The fact that you're unable to identify him or her or them doesn't mean that didn't happen. And so if you look at the court rules, it directly contemplates a situation where you don't know the person alleged to be wholly or partially at fault. Looking at Michigan Court Rule 2.112 subpart K, subpart 1 states this subrule applies to actions based on tort or another legal theory seeking damages for personal injury, property damage, or wrongful death, to which MCL 600.2957 and MCL 600.6304 as amended by 1995 PA 249 apply. Subpart K2, notice requirement. Notwithstanding MCL 600.6304, the trier of fact shall not assess the fault of a non-party unless notice has been given as provided in this subrule. Subpart K3 has subparts. All the three portion gives us is the simple word notice. Subpart A reads, a party against whom a claim is asserted may give notice of claim that a non-party is wholly or partially at fault. A notice filed by one party identifying a particular non-party serves as notice by all parties as to that non-party. Subpart 3B, the notice shall designate the non-party and set forth the non-party's name and last known address, or the best identification of the non-party that is possible, together with a brief statement of the basis for believing the non-party is at fault. And then C, the notice must be filed within 91 days after the party files its first responsive pleading. On motion, the court shall allow a later filing of the notice on a showing that the facts on which the notice is based were not and could not, with reasonable diligence, have been known to the moving party earlier, provided that the late filing of the notice does not result in unfair prejudice to the opposing party. So this is like an exception to an exclusion. You must, within 91 days after you file your first responsive pleading, file and serve a notice of non-party fault. That's a rule. The exception to the rule is if the, in this case, defendants could make a showing that the facts on which the notice is based were not and could not, with reasonable diligence, have been known to the moving parties earlier. And then the exception to the exclusion is provided that the late filing of the notice does not result in unfair prejudice to the opposing party. That's my framework of analysis. Have you anything further you wish to argue before the court rules, Mr. Tusharoni?
Thank you, Your Honor. Quickly, affirmative defense number 27 alleges non-party fault against the male patient. So they've been on notice of this with my first responsive pleading.
And that's the issue. If he knew that they were going to name a non-party at fault under the court rule that you just read, he was required to file a notice of non-party at fault with the best information he had. So assuming that you really believe that the defendants didn't know who this patient's name was at the time that they filed an answer to the complaint, which is contradicted by the evidence we've shown you, including their own statements to the security guards and the Livonia Police Department. But assuming that you're giving Mr. Tuccione the benefit of the doubt on it, he was still required under that rule to file a generic notice of non-party at fault with the best information that the defendants have. And they failed. They made a decision. He's a very good attorney, as you know. They made a decision not to do it. And now, for whatever reason, now that the 91-day window is gone, it's too late. Snyder says it's too late. It is not in the discretion of this court to allow to make a new exception to MCR 2.112 K3.
I'm not asking for a new exception, Your Honor. What MCR 2.112 discusses is pleadings, how things are pled, and pleading a notice of non-party fault. My notice of non-party fault is contained within my affirmative defenses. It's contained within a pleading, number 27 of the affirmative defenses. I pled it. It complies with the court rules. All I'm asking now is for the formality of a form that says is pretty much what affirmative defense 27 says. They are on notice. They've been on notice of a non-party fault since I filed my affirmative defenses.
What was the date? I'll interrupt. What was the date of filing the affirmative defenses?
The affirmative defenses would have been filed July 25th, 2023. Because their complaint was filed in January of 2023. But we filed a motion for summary disposition, and we had to wait around. So we waited a few months for a decision. Once the court denied that motion without prejudice, we filed our responsive pleadings, our first responsive pleadings, and that's with the affirmative defenses in July.
Judge, there's no way that an affirmative defense, a generic affirmative defense, satisfies MCR 2.112 K3. I've never even seen that argued before, and it certainly was not argued by the defendants in this case until about 1 minute ago. This court rule is very clear on the specificity that's needed to be given in a notice of non-party at fault. So even if you were to somehow consider an affirmative defense, which is a completely different animal, it's filed under a completely different court rule than MCR 2.112 K3, it was not sufficient. And if Mr. Tuccione truly believes that this notice was sufficient that was filed years ago, why in the world would he go through the trouble of drafting a new real notice of non-party at fault, which we all know what they look like because we deal with them as practitioners in just about every complicated case? Why would he be filing a motion to add a non-party at fault, which he says admits in his pleading, defendant's motion for leave to file, quote, a late notice of non-party at fault. And then in his pleading, he admits that they did not seek that they never filed a notice of non-party at fault. So he doesn't argue that at all. He says we never filed one. That's what he says in his pleading of this court. That's an admission.
So it wasn't a generic notice in my affirmative defenses, Your Honor. It sets forth the facts of the basis of that notice and essentially says, the injuries complained of arose from other causes, including those of the male patient and VS herself involuntarily consenting to a sexual act and knowingly hiding from defendant staff to engage in the act. Therefore, VS and the male patient's comparative fault negate liability on the part of the defendants.
That's a comparative fault affirmative defense. That is not a notice of non-party at fault.
But no, sorry.
Wait, I'm going to ask the two of you, we're not enjoying coffee at Starbucks. We're going to go one at a time. Right now, Mr. Marco has the floor. Finish your thought.
I've never heard of this, Judge. It's very, I think he made it up on the spot, and I got to give him credit. It's very kind of creative. But the fact is, they did not file a notice of non-party at fault. An affirmative defense saying that there's comparative fault issues doesn't satisfy MCR 2.112 K3. And they admit that by the filing of their pleading, which says that they never filed a notice of non-party at fault. And their motion is for leave to file a late notice of non-party at fault. He's giving you inconsistent arguments, Judge, and thinking that he can slide it through by now referring to an affirmative defense. And he never identified the patient by name, which is specifically required by 2.112 K3B. So if you somehow found that a comparative fault affirmative defense met part of the statute, he was on notice to amend to designate the non-party's name, last known address, or the best identification of the party that is possible, together with a brief statement of the basis for believing the party is at fault, which was never done within 91 days of him knowing all of that information, which we know because the name was specifically talked about in the deposition of Hillary Stevenson. Under Snyder, then we have to go back to the rule, which is 91 days, and it's make or break time. It's not subject to arbitrary extension. So I don't want to repeat myself. I know you hate that, but I mean, pick your poison here, Judge. I mean, it's either untimely, there's prejudice, or it's futile. But this is very creative, but it doesn't solve the deficiencies here that have been raised. And I don't know how we can get around Snyder. I just don't know. I mean, they reversed. They said it was reversible error in that case, and the trial judge said, well, it's not a big deal. Let's just there's no prejudice, no harm, no foul, and they analyzed it under the NOIs because plaintiffs are held to the strict standard. If you don't follow the NOI, it's too bad. You don't get a second chance. And they said that the defendants have to be held to that same standard because of the language in the court rule, Judge.
Judge, if I may, real quick, Mr. Marco made a really good point about the language of 2.112 K3B that I have to identify the name of the party. Until that party gives consent to identify himself, gives consent to allow waiver of his HIPAA protections, I can't use his name. I can't put his name in a notice. I can't put his name in affirmative defenses. When he signs that release, when it's then provided to us in plaintiff's supplemental brief or supplemental motion that they filed saying that all my motions are moot, and then ask for a cost or a bond because of the male patient's medical records and what they show, based upon the fact that he signed a release to use them, that's the first time I can use his name. And then shortly after that is when we filed this motion. That's really all. I think I've made it clear that we've all known this. They've known of this. They're not prejudiced because of my affirmative defense of putting them on notice that we are going to make claims about the male patient. Then we get his name. Then we file the motion for an actual formal document that says notice of non-party fault at the top, despite the fact that there's a notice of non-party fault in the affirmative defenses.
Right, but I will bite on one thing that Mr. Marco raised, at my peril, I'm sure. Do you reference the affirmative defense anywhere in your motion papers, Mr. Tuscheroni?
Probably not.
Okay. And I had to OCR document before I could check it like that, which is, again, is optical character recognition. Fortunately, my court paid for me to have Adobe Acrobat Pro, which I'm a big fan of. And so I've searched under affirmative and under defenses. Now I'll pick a word I know will be in there. Perhaps somebody's last name. All right, and that comes up. So it is working. So the first time this issue of the affirmative defenses was raised is in page 10 of 22 in plaintiff's papers opposing the motion. Right above the final paragraph on page 10 of 22, which is a one-sentence paragraph, therefore defendant's motion must be denied. In the prior paragraph, I won't read the first sentence, I'll read the second. Defendants even identified him as a, quote, male patient, end quote, in their own affirmative defenses, Exhibit 5. So I will say this is clearly very thorough lawyering. I do not disagree at all with SNY-DER versus Advantage Health Physicians, 281 Mishap 493 at 506-2008, because it says what it says, and it's reversible error if a trial court judge, allows a defendant to file a notice of non-party fault. One of the bizarre things, give me the affirmative defense number again, Mr. Tuscheroni.
27.
Okay. So affirmative defenses have raised the ire of many appellate judges. It's an unusual position. Somebody has some period of time to investigate and file a claim on behalf of a client. And then the attorney on the other side has either 21 days or 28 days, or if plaintiff's counsel in a tort action is feeling generous, more time. So what seems to happen is you have a blunderbuss of affirmative defenses filed at the complaint. The way this is supposed to work is the defense lawyer is concerned about failing to name an affirmative defense that must be made in the first response of pleading. And pleading is a complaint, an answer, and in those rare instances, a reply to an answer. And there are plenty of decisions from the Court of Appeals I've seen where they say, golly, this defense lawyer has identified every single affirmative defense you could have in an auto accident case. And now there are motions to strike them to the extent that they're not supported appropriately with sufficient factual statements. So there is an unusual tension there where we are a notice pleading state, but for affirmative defenses, there need to be additional facts stated. And so the advice seems to be you use MCR 2.118 to file amended affirmative defenses as additional facts are identified, because your initial affirmative defense could be, quote unquote, too skinny on the facts. My words, not any appellate court judge. So Joseph Heller's catch-22 comes to mind, or as was said in a cartoon, when asked to give an example of a catch-22, you're darned if you do and darned if you don't. It is odd to me, the affirmative defense 27, quote, the injuries complained of arose from other causes, including those of the male patient and VS herself involuntarily consenting to the sexual act and knowingly hiding from defendant's staff to engage in the act. Therefore, VS and the male patient's comparative fault negate liability on the part of defendants, close quote. if this were placed in a notice of non-party fault, and somehow, some way, the defendant didn't know the name of the male patient, then presumably this would stand muster under the court rule, because the court rule doesn't require a name. Exactly. MCR 2.112 K3B states the notice shall designate the non-party and set forth the non-party's name and last known address, or the best identification of the non-party that is possible, together with a brief statement of the basis for believing the non-party is at fault. That's the language. So what could have happened is, within 91 days after defendants filed their first responsive pleading, they were required to give notice of any and all non-parties having fault. The exception or exclusion to that is if a defendant can show that the facts on which the notice is based were not and could not, with reasonable diligence, have been known to the moving party earlier. And then again, the exception to the exclusion, provided that the late filing of the notice does not result in unfair prejudice to the opposing party. So I'm ready to rule. I assume you have nothing further, Mr. Marco. Am I correct?
Yes, Judge.
And Mr. Tusciaroni, do you rest as well?
So 3B is an opposite, if that's the correct word, of HIPAA, because a non-party is a patient. So I can't use names, I can't use identifying information. But that's all I have, Judge.
No, and I understand that. It is a challenge to reconcile these two. And I hate to say it, but I think regardless of how I rule, a side will appeal this, probably, well, potentially on an interlocutory basis, or more likely, after whatever happens in the trial court happens. So the issues for an appellate court to address will be, what could defendants have done? HIPAA is a federal law that precluded a notice designating the non-party, potentially. And the requirement is to set forth the non-party's name and last known address, or the best identification of the non-party that is possible. And maybe male patient is the best identification of the non-party is possible, together with a brief statement of the basis for believing that the non-party is at fault. The court receives with some regularity John Doe notices of non-party fault with some regularity. For my purposes, an appellate court may determine that affirmative defense 27 is sufficient to satisfy the notice requirement that exists in Michigan Court Rule 2.112 subpart K. But that's for them. My ruling is based upon the law as I find it. I don't know that there's any specific way that a notice of non-party has to be given, other than as stated in this court rule. I'm not going to count what was stated as an affirmative defense as a notice of non-party fault, because rigidly applying the rules set forth here, I think that there's an issue regarding satisfying that obligation. I believe it's well within the realm of reality that either the Court of Appeals or the state Supreme Court could tell me I'm wrong, and that which was stated is sufficient for there to be a notice of non-party fault. My one concern, and I'm being more specific even than usual, my concern about deeming affirmative defense number 27 to be a notice of non-party fault is we're not to litigate by stealth. And it is for that reason I'm not concluding that that was a notice of non-party fault, because if I were to hold that way, the time period for the filing of a claim against that non-party would have passed long ago. So while it meets the requirements imposed by the notice provision, it's not stated in a way where Messrs. Marco and Stare and anyone else from their office would have known they had to make a decision about what to do. Will the defendants point at the empty chair, which is allowed under the notice of non-party fault rules, or will Mr. Marco's team need to file a second amended complaint and make direct claims against the male patient? I do not yet see evidence that suggests that the two defendants are engaging in improper gamesmanship, or they're trying to pull the wool over somebody's eyes. The two defendants are bound inextricably by HIPAA, and the lawyer would be foolish to put the two clients in a position where a third party's HIPAA rights were violated.
No, I'm going to hear it.
So my ruling is as follows. Due to my concerns about due process law under the 14th Amendment of the Federal Constitution, in Article 1, Section 17 of the Constitution, or Michigan's Constitution of 1963, I find that the notice, although it seems sufficient under the court rule, was insufficient because it did not put plaintiff on notice of the obligation to make an election to either add the male patient to the litigation as provided in MCR 2.112 subpart K4, potentially, or simply allow the jury, assuming this is tried, to apportion non-party fault. I still find difficulty reconciling what I believe is in the papers in this case, that VS went to the room of the male patient, but again, they could have bumped into each other in the hall and he said, hey, I have a whatever candy bar or whatever. The issue is whether or not VS consented to what occurred. And if she did not consent to what occurred, then that is a crime. So I hope that this ruling isn't to the same effect as a football game where one team goes offsides, and so the other team, its quarterback, throws a ball or tries to throw a ball into the end zone, understanding that it'll be called back. I'm decidedly in favor of ruling on the law and avoiding appellate avenues from creating an opportunity to either create an area of appeal that could be pursued and could interrupt this case's development and preparation for trial, because a case that is ready for trial is ready for settlement. But that is my ruling. I'm denying the defendant's motion seeking leave to file a late notice of non-party fault under MCR 2.112 subpart K3. And I do underscore that I appreciate the problem with HIPAA potentially forcing a lawyer to choose between violating that federal law to help a client and subjecting that client to a violation. I would suggest that the order in this regard indicate, put in the title and date of filing of the motion, and indicate, there's a visual part for this one too, that this motion is denied for the reasons stated on the record by the court. I've got to tell you that this was a motion that caused me great pause, because I can see arguments both ways. This is one of the very rare cases where if I'm reversed by an appellate court, I'll still feel bad because I did it wrong, will be my takeaway. But that is my ruling. Have I ruled on all matters before the court today? First, Mr. Stare?
Yes, with the exception that one order regarding deposition conduct, that will be revisited in the future.
Right. We'll give you a briefing schedule and a date for that. But obviously, the agreement was we couldn't proceed to that one. But other than that one objection to the order regarding depositions, I've ruled on everything before the court today. Is that correct, Mr. Stare?
Yes, Judge.
Do you agree, Mr. Tusciaroni?
I do, Judge.
And Mr. Marco, obviously, well, you were here for the substantial measure of the argument. Is there anything else I could assist with other than Mr. Hodgman tomorrow coming up with a date and time for a hearing on the other issue?
No, Judge, thank you so much for all your really hard work and really dedication. Thank you.
Well, it's my job. Let's do this. That'll conclude the record. Wave a hand if you're an attorney on this case and you object to our going off the record briefly. All right, no hands are moving. That'll close this record. We're still broadcasting worldwide. I do like the acrimony that I saw has abated. The law sometimes is like I think the game is maybe Plinko, where the steel balls bounce, and sometimes they take an odd path. This case has very sad facts. This is a case where a jury could go one way or the other, maybe not. I only know a portion of the case. I encourage both sides to look at the ability to resolve this case. My expectation is that the current demand perhaps makes it difficult for the defendants to counter. I encourage defendants through their counsel to not let that get in the way. I would encourage, to the extent you can, Mr. Marco, and I can't order this, nor would I, but to the extent you could present documentation to Mr. Tusciaroni explaining your rationale for settlement. I think that could help. This case has a lot of issues that are unusual. It's a good thing because the facts are tough. I recall that video with the petite physician. I think it was the gal whose name was mentioned, Stevenson, maybe, in the hallway with the police officer's body camera. And so that's where we are. So keep working. You have enough time to get done what you need to get done. I would encourage counsel to keep talking. If there's going to be any effort at making a third-party claim against the male patient, one of the things I'd encourage both sides to think carefully about is it could change his thought process about this matter. Make sure that Mr. Riley has a copy of the operative complaint. The first complaint was filed on January 23rd of 2023 at 9:52 a.m. And the current complaint, the amended complaint, was filed at 5:10 p.m. that same day. The claims are titled Count 1, Ordinary Negligence, Count 2, Failure to Report in Violation of the Michigan Social Welfare Act. And there's a cite. And then Count 3 is the denial of full enjoyment of public accommodations in violation of the Elliott Larson Civil Rights Act. I would ask you to each be very thoughtful on what those claims constitute. whether each of those claims or some of those claims would be a tort action or not, which is where those notices of non-party fault, they're limited to those instances. But those are my thoughts. Any thoughts any of you would care to share? I know I've held you captive for long enough, but in order, top to bottom of the caption, Mr. Marco, anything else for today?
No, Your Honor.
Mr. Stare, anything else for today?
No, Judge.
All right. Anything else today, Mr. Tuscheroni?
Just to clarify, Judge, how you want me to submit that male patient deposition transcript? Just email to Brian with the CC to Mr. Stare and Mr. Marco.
Yes, and then that way they know exactly what Mr. Hodgman receives. He can dump it into an electronic folder so that I can review it. Make sure you put all sorts of statements indicating that this material consistent with the court's direction on, it's still May 21st.
Judge, I'll put in there that I'm sending it regardless of per the court's order, per the court's direction.
Per the court's direction, but understanding that it's being submitted for an in-camera review. Right. Counsel for each of the three parties has a copy. The court is being provided a copy, and then Mr. Hodgman will also give you direction on any additional briefing. Mr. Marco, Mr. Stare did a pretty good job of summarizing the area of briefing that he felt was necessary. And one of my concerns about this case is it's sort of a whodunit, and you've got two individuals who, based on what I've read, have different ideas on what happened. But I think if the two sides are able to resolve this case, that's all for the best, because it's very hard to successfully appeal a settlement. So I wish each of you a good day. We've gone a bit late. We're after 5 o'clock in the evening. But good luck. If either of you or both sides appeal these successfully, I'll be bummed, but we won't speak of it because I take all this stuff way too seriously. You guys have a good day.
Thanks, Judge.
Thank you for the time today, Judge.
All right,
Thanks, Judge.
Thank you.
All right, see you guys.